And welcome back. Time for Opinion Court, and we hope you're getting in touch with us. We'll be reading your views very shortly. As I mentioned earlier, we're discussing the amendments to various election laws that Jubilee has proposed. This is now before the National Assembly and the Senate, and we want to show them to you very quickly before we get into our discussion. So as I mentioned earlier, there are various pieces of legislation that have been targeted. The Election Offences Act of 2016, when it comes to access of information, Section 14.2, it deletes the section forbidding the incumbent government from advertising its achievements during the campaign period. What do you know? All right, to the other piece of legislation, the Independent Electoral and Boundaries Commission Act of 2011. In Section 2, the definition of the chairperson has been amended. It delegates the IEBC chairman's responsibilities to the vice chair or a delegated commissioner in his or her absence. Section 6 of the same Act, the qualifications for the appointment of the chairperson of the commission, it drops the requirement that IEBC's chair must be a lawyer. And in the same area, the amendment of the second schedule, it requires IEBC's decisions to be put to be by a majority of commissioners, but reduces the quorum from 5 to 3. And then the other piece of legislation targeted is the Elections Act of 2011. There's an amendment of Section 39, the determination and declaration of results. It makes it mandatory now to transmit presidential elections electronically and manually, but makes manual results superior in the case of discrepancies. And then there's a deletion and substitution of Section 44A of the same legislation and the complementary mechanism for the identification of voters. It relaxes the requirement for IEBC to provide for a complementary voter identification mechanism. We're just about done. Let's look at Section 83, the non-compliance with the law. Listen to this. It forbids judges from annulling elections over failure to adhere to procedures that do not affect actual voting. And then finally, there's a new section that's being introduced, 6A, failure or refusal to sign results. It prescribes a 5-year jail term for returning and presiding officers who fail to sign election forms. And so, as you can see, based on those amendments, a lot of them influenced by the issues that we saw that led to the nullification of the August 8th presidential poll. So let me reintroduce my guest for you for good measure. To my immediate right is the Deputy Speaker of the Senate, Kithure Kindiki of Jubilee. Next to him is independent lawyer Steve Ogolla. Next to him is Edward Kisiangani, who is our resident political analyst, and next to him is the minority leader in the National Assembly, John Mbadi. And you're all welcome to the program, gentlemen. Let's begin with you, Kindiki. What is it that you're trying to achieve through all these amendments?
Thank you very much. There are 4 things that are the summary of those amendments. Number 1 is about IEBC. Making decisions of IEBC better and faster, including issues of quorum, but in particular the role of chairman, which you have highlighted as the returning officer. And simply put, we are saying that, for example, if on the day that the chairman is supposed to announce results, he has a sore throat, for example, and cannot talk, the country should not be thrown into crisis. The deputy, that's the vice chair, could as well announce on behalf of the commission. So there are a few amendments there around making decisions of processes of IEBC better and faster. Secondly, election offences. These amendments have come from the judgment of the Supreme Court in the recent petition, which succeeded, which was brought by NASA. And we are saying that, for example, if an election official refuses to sign an election-related document, it should be an offense. He should be jailed for 5 years. If an election official falsifies a document, as was said in the majority decision of the court, that person should be held accountable. Or if, for example, they file an incomplete document. And by the way, we have information that part of the reason why some of the documents that the IBC received from the field were found wanting is because there could have been collusion between field officers working for IBC with certain political operatives to frustrate the election. You simply file an incomplete form or falsify, etc., etc. So we are rectifying that. Number 3, those amendments are about the complementary mechanism, which already existed in Section 44A, which now we have clarified. Again, the Supreme Court said that there is no clarity on the relationship between the electronic transmission system and the manual transmission system. And based on that decision of the IBC, of the Supreme Court, as read together with the court's judgment in the minor KI case, we are saying that results will be declared at the polling station, collated and tallied and announced at the constituency, and those results are final. So the evidence should be those forms. That's what the court said, because NASA went to court and said Chebukati announced the results without receiving all the forms, etc., etc. He relied on the electronic version. So we are saying to cure that, if there's a discrepancy between what has been relayed electronically vis-a-vis the actual forms, then the actual forms prevail. Then finally is amendments to do with a new Section 86A, which deals with what happens if there is a petition that nullifies a presidential election, as we have had the case. You have seen Ekuru Aukot, who had vied for the presidency, trying to be a participant in the fresh election. And so we are clarifying and saying it's only the person who petitioned and the person who won who should participate. And where the petition has been brought by a member of the public, then all candidates who participated in the previous election are free, if they wish, to participate in the fresh election. That is the summary of our amendments.
What do you think of that, Mbadi? I know in Parliament today the exceptions that you had were raised, but in summary, when Jubilee paints this picture of this is about filling gaps in order to secure the next presidential election, what is your understanding of what they're doing?
And let me tell you that what is happening with Jubilee is like when you lose a loved one and the body is still at the mortuary. It takes you time really to accept that it has happened. That's why a lot of times you're advised that when someone loses a loved one, you provide counselors to help them go through that period of time. I think what we have forgotten in this country, that leaders can also suffer from that kind of eventuality, and therefore they need counselors. What Jubilee needs, Jubilee leadership, from the president even to their members of parliament, is to be taken through counseling.
Grief counseling.
Real counseling session. I think losing this petition has shocked Jubilee to the bone marrow, to the extent that they don't know what to do. If you listen to the president, his deputy, and the Jubilee Brigade, they have been talking of, yes, we don't agree with the Supreme Court decision, but we will accept it. We thought they meant it. But now with this, what they have done, in fact, when I looked at these two sets of laws, the Election Offences Amendment Bill and the Elections Amendment Bill, it just demonstrates that the failure by Jubilee in the courts to rebut the case presented by petitioners, they think they can retry this case outside, and more particularly in Parliament. Why do I say so? My friend, Professor Kindiki, knows very well that in amending laws, you need to do these amendments before the process starts. You cannot amend laws to affect a process that is ongoing. And that is exactly what they are trying to do. If you look at some of the amendments that they are proposing, they are ridiculous. Number one, if you are trying to redefine the definition of the chairman of a commission, definition of chairman, and chairman has been given a responsibility in the Constitution to be the returning officer for presidential election. What are you doing? Secondly, when you try to remove the requirement that the chairman, and that is the only position which the law has clearly provided that the chairman must be someone who qualifies to hold the office of a Supreme Court judge. The others, they would have to be judges. In fact, as we speak, the only lawyer in the commission is the chairman. IEBC as a body sometimes converts itself into a tribunal to hear and try cases. You cannot have a tribunal without a lawyer in it. And Professor Kindiki and his group know that very well. And they have decided to close their eyes because of political expediency. They want to take us back to where we came from just by this kind of action. The second one, and I want to really explain this very clearly in 2 minutes, if you allow me. This amendment on electronic vote transmission, we negotiated it. Remember when Craiglock came to Kenya in 2008, one of the flaws that he found with our system was the manual voting system. And he encouraged us to go electronic. Now, what is happening is that we sat and agreed as a country that what we would want is after the voter has cast his vote, and they have been talking loudly about protecting the will and the wish of a voter. I go to a polling station like I vote in Godolo Primary School, for example, in Suba South constituency. Immediately I vote, the votes will be counted. And once the votes were counted, like they were done on 8th August, Uhuru Kenyatta got 3 votes in that polling station. And Raila Odinga got 695. Those votes were entered into a form called Form 34A. The law requires, as it is today, that you scan that form. It's not about sending the figures. It's about scanning the form and sending it electronically simultaneously to the National Tallying Center, the Bomas of Kenya, and also to the constituency tallying center, which in my case is Tonga Boys Secondary School. Now, once that is transmitted, it is understood that the reason why this was supposed to be done was to avoid human interference. Now, what our friends are telling us with this proposed amendment on Section 39 is that you will transmit that electronically. You also do it manually, which also happens. But now, if in the event that that form that you scanned immediately, which was signed by the agents, in the event it differs from the manual form that is delivered physically here, maybe after 2 days on the road,
which also must be signed by agents.
When you arrived in Nakuru, someone called you and told you, how many votes did Uhuru get there? He got 3, make it 300. You make it 300, that when you arrive at Bomas of Kenya with that form, now indicating Uhuru Kenyatta's got 300, that form now will override what was sent electronically immediately. What kind of absurd and crazy amendment can ever be generated in a country civilized or supposed to be as civilized as Kenya? I think, as I conclude, Anne, the truth is that let Jubilee sober up. Let them just sober up. Let them not act in anger. In fact, it is said when you are angry and emotional, please don't act. I think Kenyans need to tell their president and his deputy, you are angered because you feel so offended. It is a very bad tag, by the way, that you are the first president in Africa to have his election annulled. It is frustrating them, but let them relax.
Okay, Steve, your independent legal view, are these amendments an emotional response, as Mbadi is alluding to, or are there fundamental issues that are being addressed here?
Well, and I agree, this is a knee-jerk reaction. The promoters of this bill are keen on amplifying the intended benefits, but a careful scrutiny reveals that this is in fact a clear attempt to preserve the outcome of election irrespective of any challenges the election may have. And I may be able to just demonstrate a few instances, because I know most of them have been spoken to by Honorable Mbadi. There is an indecent and illegal reassignment of functions from the chairperson, under Article 138, sub-Article 10. The chairperson is the person who declares the results. You cannot reassign that function through legislative innovation. Secondly, there's an attempt to insulate IEBC from what would otherwise be election-related offenses. And then, because then it says, you will preserve the election, we will deal with those people later. Number 3, it seems this bill seems to limit in a very significant way the Supreme Court's ability or options to nullify an election outcome, because it says that where there are discrepancies may be there electronically, but you have to go with what is in the manual form. And then number two, remember Section 83 of the Elections Act was an issue was an issue that was hotly contested. NASA was promoting the understanding that it should be read disjunctively, meaning you look at compliance with either the compliance with the law or the numbers. Now, Jubilee seems to appreciate or to privilege an option that now requires, if you look at this bill, both aspects, a conjunctive approach that, well, process matters, but numbers also matter. That, in a way, then is intended to shape the options that the court has. And also in terms of the statutory provisions that allowed for access to software systems and data have been deleted. You know, those provisions, Section 44, this bill now deletes those provisions so that anybody who seeks to rely on those provisions to access data will have no legal foundation to make such demands. And I think there has to be an opportunity for innovating, creating opportunities for assuring the transparency of without resorting to approaches that may then embarrass Parliament if someone has to go to court and the court must then nullify this legislation. So what would the impact of this legislation then be on the presidential election if passed and assented to? The obvious impact, because its legality is doubtful, one, because of the processual issues in terms of process. You heard from what we watched earlier in the day, the ad hoc committee. First of all, there's an ongoing debate whether an ad hoc committee can process this bill. And even if it can do so, whether it can do so without representation from both sides of the political divide. Then there is, of course, the substantive issues, some of which now we have highlighted. I think the net effect of this, plus the other issue which is now going unattended, whether these laws can actually apply to this election. That's an issue that cannot be ignored. I think if you look at these laws holistically, what it intends to achieve, it intends to make it easier to preserve the outcome of an election. I believe there's a way to innovate, to create the preservation. I think where the promoters of this bill is missing the point, Anne, the Supreme Court stated that the problems are internal to IEBC. They are not external to IEBC. So you don't need necessarily legislative intervention. You don't need a judicial intervention. IEBC needed to reflect and then make some honest admissions and then publicly and tell us how they intend to recreate and then build that confidence, because already the court said IEBC failed to comply with the existing laws every step of the way. Now, instead of burdening IEBC with additional laws, can IEBC communicate with clarity how they intend to create that public confidence, how they intend to address concerns not just by NASA, I believe also by Jubilee, because Jubilee also said they have their own issues. Right. I think that approach is what may improve election management. Prof, let me ask you this, and if you could pick it up from what Steve has said, that perhaps, and if I'm understanding you correctly, then Jubilee's fundamental problem is not so much legislation, but is IEBC's compliance to the law strictly, which is what the court found it had not done. In which case, Prof, who do you see Jubilee's main opponent being in this entire electoral issue? Is it IEBC? And if it's IEBC, then are they dealing with it correctly? Is it NASA? Is it the judiciary? And which does this approach, this legislation deal with the right challenge?
I think, first of all, Anne, let's begin with the first major item. The major item is the Supreme Court ruling. The Supreme Court ruled on and pronounced itself on two things. It said that the elections have not been conducted by respondent one in accordance with the law and the Constitution. So, two, respondent one, who was the IEBC, must conduct this election strictly in accordance with the Constitution. That is the word that was underlined actually by the judge under the law. So that means this. On one hand, Jubilee is saying we want, and in accordance with the Constitution and within 60 days. So Jubilee is saying we are ready to hold the elections within 60 days. That is acceptable. They are right, and therefore, even if they didn't pronounce, the courts didn't pronounce that, we would still end up with that election in 60 days because the Constitution says so. The second part is now which concerns NASA. NASA says we would like to have elections in 60 days, but the process matters as pronounced by what? The Supreme Court. So both of them are right. What they don't have is to agree how to proceed.
Is this the way to proceed?
The way to proceed. So now, but from this bill that we are looking at, the amendments we are looking, you look at Jubilee, which is now saying, they have refused to accept the Supreme Court ruling. That's the first ailment that Jubilee is having. They don't want to accept the Supreme Court ruling, so they are rushing to condemn, as the president put it, to revisit. So they are trying to go to this, to deal with the Supreme Court, put legal obstacles that will ensure a smooth win for Jubilee, which is not very good for our country. I think what Jubilee needs to do is to accept the Supreme Court ruling that didn't go their way this time. Maybe next time it will go their way, but say, let us look at the legal issues. Can we ask IEBC, do we have anything that we can assist you to deal with in parliamentary sense? Legislation alone is not the problem. So from Steve Ogola's point of view, the crisis in this electoral process is not legislation or lack of it. The crisis is that there is enough legislation, but it was violated by IEBC. According to the Supreme Court ruling. You don't have to agree with it, but you will accept that it was violated. So therefore now they say, if the IEBC is capable of dealing with these internal problems of legislation, of violations, without necessarily going to Parliament, it's IEBC to say that.
Okay.
Now, but as we look at it, I wanted to suggest this, Anne. This legislation is an attack on our constitutional order in this country. It's an attack because when you remove something that no government shall publish any advancements of achievements, by publishing that information, you attack the Bill of Rights. Various sections of the Bill of Rights that begin with Article 19 up to 57, which gives different freedoms, because by announcing this, another candidate will say, my rights are violated because I have not been president, I have not been in government, but the one who is in government is already violating my right by announcing what he has done. So if I have not done, I'm already starting at a loss. So in that case, any attack on the Bill of Rights needs a referendum, according to Article 255, 256, and so on. So, secondly, you look at the question of chairman. The whole section of the Constitution, and which deals with independent commissions and offices, begins with Article 248 up to 254. It gives general guidelines on how independent commissions should work. So when you isolate one independent commission and define a chairman for one independent commission and not all the other commissions, such as the Police Service Commission, the National Human Rights Commission, what does the other chairman of other independent commission do? Does he fit here, or it only applies to the independent commission you call the IEBC?
All right.
So in general, Anne, what I'm saying is that sobriety should prevail, because the basic point here, and which everybody, including NASA and Jubilee, should be discussing, is that why is the presidential election so emotive? Instead of coming up with the legislation, my distinguished brother, Kindiki Kithure, should be saying, the reason why presidential elections in Kenya are so emotive is because people are so ethnically divided. So what Parliament should be addressing today is not legislation like this to enhance ethnic enclaves and subdivisions, but to say, how do we cure this so that presidential elections cannot be so emotive like they are.
Okay.
So this is where they are failed.
A lot has been said. And Kindiki, I know you're itching to respond to all of it, but if you would also touch on the same issue of, is Jubilee addressing the real problem? Is this, in a way, still failing to see what led to the annulment of the presidential election? How does this cure the fundamental issue that it was a lack of strict adherence to legislation that led to the annulment of the presidential election?
Thank you. Now, first and foremost, this is not the only intervention that Jubilee is going to make. It's just one of the many interventions. It's a legislative intervention. I don't know why we are making it so emotive, and some imaginary crisis is being created out of it. With my brother here, John Bandy, who now has converted himself into a councillor of sorts.
Now, a grief councillor, no less.
Parliament, the purpose of Parliament is to make legislation. That is the forum where legislation is cooked. The process of attacking legislation that you think is bad is by representatives of the people going and making those arguments in the floor of the House. Now, if you make those arguments in the floor of the House and lose the final vote, there is even another exit. You can go to court and challenge the law. So, and there's a contradiction here. Parliament is doing its work. That is our view as the majority. And I don't think that majority should be condemned, because even the Supreme Court decision, which all of us are mentioning here, is a product of a majority decision where some of the judges actually had a different view, but because they were few, that view is irrelevant in terms of outcome. So, and for us, number one, Parliament is doing what it should be doing. If our colleagues have different views, let them come to the floor of the House to convince us. Who knows? They might change our minds. Who knows? The solution is not to go and throw stones on Monday and destroy people's shops and wares. The solution is for Mbadi, who is the leader of minority, to come and make those arguments, including the cancelling arguments, on the floor of the House. And by the way, Anne, this is a serious matter, and we are talking this as Kenyans. The same way they are seeing problems with the Jubilee side, the same way we have also issues with the minority side. I have been in Parliament the last 5 years. Neither the leader of minority in the National Assembly nor the leader of minority in the Senate has generated one bill. They keep on accusing us of tyranny of numbers. But the work of opposition is to say, okay, Jubilee has brought this legislation. This is our solution to this. And they have never brought anything that was thrown out by the minority. They only wait for our legislation to fight and throw and pour water. Secondly, Anne, on these amendments, NASA went to court and said that some forms were not signed or they were falsified. We are saying now in this amendment it's an offense to falsify or refuse to sign.
It's a violation of the Bill of Rights, Prof.
Just a minute.
You can't force people to sign if they don't agree with anything.
The point is this: you have not read the amendment, Professor. I have a lot of respect for you, but what the amendment is saying is any election official, for example, who is required by law, for example, to sign a certain form and refuses to do so, or falsifies or gives an incomplete. Some of the forms were incompletely, they didn't have signatures, etc. That is where the offense arises. So, and those are the amendments. The issue of the chairman and IBC. Let's see all those views. Let's see all those views in Parliament. But I want to submit that all the independent commissions don't have identical functions, even terms of terms of service. They are not identical. The NSIC chair doesn't serve the same term with the chairman of another commission, TSC commission, for example. So you cannot tell us that what happens to the chairman of IBC might happen to every other chairman. Finally, is to say that this country, the future of this country, lies in using the institutions that are established, however flawed, making corrections and improvements on those institutions as we go along, but not to try and vilify institutions, vilify, for example, a democracy. You win an election and all of a sudden you become now a victim. The fact that we have many members of parliament has become is a bad thing. So this country has a genuine problem, and that is a problem of making sure that we use institutions to articulate our views, however different. And for us in Jubilee, we are prepared to lead the way. We want to ask our friends to abandon the destructive and dangerous trend of trying to intimidate the majority through violence, through frustrating businesses and the economy, because that's...
Go ahead, Mbadi, you're making a response.
You know, Kindiki is now trying to veer off from the discussion, and I see why he's doing that. But let me take us back to the main discussion that was going on. First of all, let me put it this way. Signing of the forms. And Professor Kindiki knows very well that there is already a law in place. If a presiding officer or a returning officer fails to do his duty as prescribed, is punishable. It's already there in law. I don't think this legislation is helping anything. Secondly, again, Professor has talked about the opposition has not been bringing legislation. The leader of minority, I believe he's talking about my predecessor. But the professor knows very well that the legislations that have been coming to parliament are actually from the executive, from the ministries. It's not their legislation. It's not the members of parliament bringing this legislation. As a matter of fact, if you go to the 11th parliament records, you'll find majority of private members' bills came from CORD coalition. I brought 2 bills, and I doubt whether how many of your MPs did that. But anyway, that was not the subject of our discussion today. What is Jubilee fighting? Jubilee is fighting 2 groups of people here. Number one, they are fighting with the Supreme Court judgment. That is the biggest problem. If you look at these amendments, they are targeted at the case that was taken to the Supreme Court. The petitioners' submissions in court is what they are attacking, together with the judgment of the majority of the judges. 2, they are also fighting some imaginary enemies in IBC. I call it imaginary because you look at the amendments, they are targeting the chairman's position, and that is for a reason. I don't know why you are, Jubilee is already contemplating the absence of the chairman of IBC on the date of announcement of the president's result. And the chairman can only be absent if the chairman dies, or the chairman resigns, or he refuses to do his job, in which case he would be prosecuted. So, in my view, I am worried that Jubilee is already contemplating the absence of the chairman. 2, they are again contemplating, or rather attacking, some imaginary enemies in the IBC among the commissioners.
Please, just on that one. And you know, when the Supreme Court was deliberating on this petition, one of the judges, Justice Ibrahim, could not attend. He was indisposed. So it's not fair for John Bundy on national television to try and throw innuendos that perhaps there could be something ulterior in imagining that a chair of a commission, who is a human being, can be absent on a critical date.
You know, it is not just being absent. Let me tell you, I've never seen anywhere, and we have read this constitution, and by the way, Professor Kisiang'angi was right. You look at Article 248 of the constitution, it names commissions and independent officers, and IBC is one of the many commissions that are enumerated there. The process of having chairmen and other commissioners in the commission is almost identical. And as a matter of fact, I have the benefit of sitting in the 10th Parliament and sitting in CIOC committee, which was midwifing this constitution. And we passed these laws that govern the commissions. I know that we almost duplicated and replicated the establishment of those commissions. Now, if you look at this amendment, it is so interesting that for the first time you are finding an act of parliament defining chairperson. You know, if it is different from saying that in the absence of the chairperson, the vice chair will act, or some other person. This one is actually defining the chairperson of a commission. Chairperson of a commission is always known. It is always one, the chairperson. You can only act. But here is a case where someone defines chairperson means the chairperson, right, then goes ahead to say, or the vice chairperson, or any other person.
Let me ask you this, Mbadi. If these amendments pass and are assented to in record time already, you know, the whole maturation period was put down to 1 day. What is NASA going to do? And of course, you can expect that I'm sure Jubilee wants this implemented, you know, in the upcoming presidential election. What will your options be?
First of all, let me tell you, well, let me just conclude what I was saying, that the main reason why chairperson has been defined here is because they want someone else to announce their preferred presidential candidate, their president. They want someone else to announce that Uhuru Kenyatta is the president. That is the reason on 26th. Other than Chebukati, and for the reasons best known to them. But let me answer your question. If they insist on this, and they seem to be adamant, 2 things. Well, I know any Kenyan, not necessarily NASA, would go to court and have these laws declared unconstitutional. That is number one. Number two, as a matter of fact, IEBC needs to ignore these amendments, even if they pass. If I was the chairman and commissioners of the IEBC, I ignore, because these laws are unconstitutional. Constitution is supreme. Any court should ignore this. But as NASA, we are not even going to allow them to pass these laws. From Monday, we have mass action in this country, all over the country. And it is now not about IEBC reforms. It is not about the reforms of the infrastructure at the IEBC.
How will you stop Parliament from sitting and passing these laws?
Let me remind this, our viewers that in 1981, Section 2A was passed in the same style. Kenyans had to lose their lives to have it repealed. We are not going to allow another Section 2A to be again passed. This time round, we would rather we sort out this mess before it happens.
But how will you stop Parliament from?
But the will of the people can stop anything. Parliament is an institution with delegated power from the people. The will of the people will stop this Parliament from behaving the way
his strategy, and that is his strategy. But for us, we believe in the rule of law, so we shall still defend the Constitution.
But Professor, even the will of the people is the rule of law.
It's okay.
Yes.
You have
I'm not saying that we are going to beat people.
Yeah. Okay.
I'm not saying we are going to cause violence.
But
I'm saying there is the will of the people.
I agree with you, but I wanted to add, because so that we for the sake of our viewers, I wanted to ask Professor Kindiki, suppose you pass this amendment and that in 2022 you are running as a presidential candidate, Prof. And then, because the law says that you can get another chairman, your competitors go around and appoint chairmen from their own tribe to announce another person as the winner of the election. What will you do?
That's hypothetical.
No, it can happen because people can go around it. And then they announce a wrong person because they don't like you. What will you do?
Relax, I want to support you, Professor. When we went to law school, we were taught, and later on we started teaching students that if you want to know a good law, when you are making it, if you want to know if the law is good, you must always imagine that law in the hands of your worst enemy. That your worst enemy is the one applying it. So we believe that these amendments, much of them stem from the ongoings and what the court actually said needs to be clarified, especially on the complementary mechanism and other things. We believe they are good law. That is our view. If NASA thinks otherwise, and other Kenyans, because we are going to have public participation for the entire of next week, both houses have adjourned for a week to allow public participation. That discussion should come through public participation. Let the public come and overwhelm us with those views. Let the elected members of NASA come and articulate those views when the second reading and the committee stage are there. And I said, who knows, they might convince us.
But my question, what would you say, Prof, with my specific question, even if it's hypothetical? Don't you see such a situation happening? So what would you do? Because you are defending this.
Nothing will happen. You know, if I'm vying for president in 2022, the announcement will be done in accordance to the law which will be in place at that time.
Suppose it is this one and then they...
Can I weigh in?
Because you will not announce the results which are not there. You'll announce results as they are.
Let me weigh in, Anne. The fact of the matter is this. What the Supreme Court said, it is redemption time for IEBC. No matter how much you examine it, this is redemption time for IEBC. And any legislative intervention to support the emergence of the preservation of the electoral process, the purity of the electoral process, and the integrity of the vote must be able to focus specifically on IEBC, if IEBC needs it. Now, what I see as a gap here, Parliament is failing to capture the judicial thought, the legal philosophy. You see, already judges have come out and have said, this is our philosophy, let the heavens, let justice be done, even if heavens may fall. And the people that will cause the heavens to fall is the IEBC. It's not Parliament, it's not Raila Odinga, it's not Uhuru Kenyatta. The focus is on IEBC. And when I was reading this judgment and attempting to pull out some key issues, what the court is saying, that IBC needs to observe compliance with the law. And I think Jubilee and NASA care for the credibility of this election. There are so many laws that IBC must begin to study, if they have not already studied them: the Constitution, the Elections Act, Election Offences Act, the Public Officer Ethics Act, the Public Procurement Act, Leadership and Integrity Act, the NCSC Act, IBC Act itself, and then begin to interrogate, where did we go wrong? And in the process of that interrogation, communicate how they want to make reasonable adjustments that is satisfactory. Because remember, an election is about perception. If management of the election process, the electoral process, if it is well managed, but the people don't believe that it is well managed, the perception that will be sustained is that that election has been mismanaged. IBC needs to bring not just the ability to respect and comply with the rule of law, but the ability not to allow reasonable Kenyans, the right-minded in society, walk away thinking that IBC is either incapable or incompetent. In compliance with the law, the second issue I saw from the Supreme Court is the question of openness. The court is saying we are not ready to tolerate things done in obscure manner. Let IBC, in fact, Anne, the leaking of those documents by Chebukati, you know, the order of governance says the government is porous. So it's a nice thing that memos were leaking. Those ones have a psychological effect on the masses. If Chebukati is struggling internally to hold people accountable, you get, and that information is leaking the public, that has a pacific, it can pacify feelings, people who believe that IBC may not be willing to readjust. And that, I hope that more leakage can continue flowing. Goodness. Then in terms of competence.
Finally.
In terms of competence, IBC must be careful to be sure that the illegalities, in the sense that what the law requires you to do, you must do. What the law prohibits you from doing, you must abstain from it. And the irregularities, what is not ordained by the law, you abstain from it. If IBC can achieve compliance with the law, openness and competence, I think they'll win the perception and the confidence of the people, and the election now will be much better managed because of that perception that we'll obtain. All
right, we're absolutely out of time. I would love to give you final comment if you would strictly adhere to 1 minute, and I'm literally going to time you in doing so. And let's wind up on this note, the fact that we saw today NASA storm out of the Bomas stocks occasioned by this particular piece of legislation that is coming up. You were in Bomas, Kindiki. Is this the end of Bomas talks? How far had you gotten to? And in the absence of talks at Bomas, what will bring consensus on how the election should be run? 1 minute.
Thank you. There were no talks in Bomas. The issue of talks was creation by NASA and sections of the media. What there was at Bomas was a meeting summoned by IBC, the umpire, inviting parties who will be participating on the election of 26th of October to discuss certain agenda, much of which was brought by our friends in NASA. So it's the meeting that never succeeded.
But there was no talks, no negotiating, there was no negotiation, not part of your agenda?
No. Our only interest in that meeting are two. One, we were asked to attend by the umpire, and two, we wanted to find out how prepared the umpire is to run the election, because we as a party believed that.
So nothing collapsed because there was no talks to negotiate. It was just a meeting. Okay. Okay. So in the absence, so the meeting happened and we can go to the elections.
Then the agenda of NASA, which was to discuss procurement issues about Al Ghurair, to discuss things to do with who cooks tea in IBC and who must not cook tea, HR issues, which we are not interested in.
This is much ado about nothing, is what you're saying.
Yeah, precisely.
Okay, Buddy,
but we need to know how prepared IBC is to run the election, for the reasons which Council here and my colleagues have said, because we don't want the same mess again to happen.
What was NASA's understanding going into this meeting? Was it talks? Did you negotiate? Is the failure, your walkout, significant? Does it impact how the elections will be run?
Well, I may not really comment on what brought about the walkout much, because I wasn't in that meeting, but I've heard a little about it. Our understanding was that IBC was reacting to the memos that we have been sending to them, and the memos that Jubilee has been sending to them. So we were going to discuss in a structured way issues of concern to us as stakeholders, which is provided for in law. But you can see the condescending attitude of Jubilee, the arrogance that is exhibited by, from unlikely quarter of Kindiki, is not known to be exhibiting the tendencies of arrogance, at least previously. Today I'm a bit shocked. But I think what we have seen and what we are objecting to is that what the president talked about, revisiting and fixing, we didn't know it would start as early as now. We thought if there was supposed to be revisiting and fixing of the judiciary or the electoral system, it would come after, in which case we would deal with it because we knew we were going to beat him in the elections. But it has come too early, so we have to really stop the president together with his deputy and his choir from really messing this country in the name of revisiting and fixing. All right,
Steve, in the absence of Boma's meetings, talks, I'm not sure what to refer to it now, what's the way forward for IEBC in the face of NASA's demands?
Two things. One, for this political class, they should not underrate Kenya's ability to give up on both NASA and Jubilee and chart their own way. Meaning, it's not beyond us to just go to court to seek a judicial intervention on all these crises. You can just manufacture political crisis, then expect as Kenyans to just sit there and tolerate you. Life must move on, and NASA and Jubilee must get serious. And IEBC is at the center of all these games. IEBC must now tell us in a very timeless manner when they intend to bring all these things to closure. Time is running out, and we have less than 30 days to the election. We don't want these issues to be carried over to the next week. The outstanding issues, we want to know. What are these outstanding issues? Is it cooking tea? Is it Algurea? Is it OT Mofo? Is it IEBC staff leaving? So that if there is no settled approach, because you've said before, IEBC as a constitutional commission has the ability to approach the Supreme Court for an advisory opinion on what they think is the sticking issue, which is not solvable on the table. If IEBC is neglecting that opportunity, it is not beyond us Kenyans to activate the provision of Article 165, Sub-Article 3, that requires any Kenyan to approach the High Court for a judicial intervention. And the outcome of that judicial intervention shall be binding on both NASA and Jubilee. We want an end to this. If you're having elections, let us know in advance. Let campaigns happen quietly, but we don't want political brinkmanship that is setting this country on the edge again.
Okay, so in the absence of Bomas, it's court, is what you're saying.
Yes, yes, yes.
Prof, finally.
Exactly what Steve is saying could be part of the solution. But let me just, for purpose of our viewers, say this. There is no winner here. If Jubilee goes ahead and say, let's hold elections despite the process, you will never win. You will have put in place a crisis you will never put off. If NASA, on the other hand, say they can't discuss methodology unless there is, they can't discuss the date unless there is methodology, and they don't want to cede some ground, again, there is no winner. The winner is all of us Kenyans, and these people must talk. The point that is clear to us that these two groups, Jubilee and NASA, are courting a serious crisis. It is like when you walk out of your house in the morning and you realize your own kid, 5-year-old, is laughing but touching the tail of a spitting cobra. So you don't know whether to bounce on a cobra, you don't know whether to carry your baby away. These two groups are behaving in a very infantile way. And it is important for the Republic to tell them that you are not Kenya. Correct. And therefore, the infantile nature of their approach to this serious crisis is the spitting cobra will bite somebody, and somebody will die because of poison. You are courting a crisis, and you will be held responsible if this country collapses because of this grandstanding. Come together, sit together and discuss what is possible to be done before the election day to correct the process, let it be corrected. What is not possible, NASA should give way and also say, let us take this because of the time, and let us have an election and have a president in the next 27 days. That is what Kenya wants. Kenya doesn't want to see you in conferences and in places where you are showing how tough you are, how many majority you are, how marginalized you are. That does not wash.
And That's our time. I thank you all for your views, and I thank you for watching. Unfortunately, we don't have time to take your feedback, but we so do appreciate it, and I'll be reading it once this broadcast is off the air. I am Ann Kiguta. Have a wonderful evening and a great weekend ahead. Bye-bye.